I was up in London this week, being educated beyond my capacity. I was on a course about advocacy and vulnerable witnesses. I'll do some more on this further on, but I just thought I'd give you a little introduction to it because I thought you might find it interesting. Um, the course had identified a problem with how barristers cross-examine vulnerable witnesses, and it started out with young children. Because, it was people going in there and sort of going, proper cross-examination and putting their case and accusing them of things. And you've probably all heard these horror stories in the newspapers. So it was recognised that something needed to be done. We needed a different approach. And the idea was that fundamentally what we want is the best evidence from the witness. And that isn't necessarily, obtained by steamrollering them or bullying them. So they introduced what they call ground rules hearings. And that's, as the name suggests, where before a trial or before a witness is called, everybody gets together and the judge says, it's also up to the judge, the parameters of what you are allowed to say in terms of questioning. It's always the judge's final decision. You can argue about this. And the judge may say something like, I want to see your actual questions. Or sometimes they might say, I want to see, I know you've been doing this a while, I trust you, but let's just put some sort of, limits on how you're going to approach this. There'll be somebody called an intermediary who acts on behalf of the vulnerable witness, and they will make suggestions as to how to, best question them and, for their specific circumstances. But again, they're just advisory, and you can challenge and say, for instance, well, actually, I disagree there. I think this child is fine, or I think this vulnerable witness is fine. Because now it's not just children, it's anybody who's potentially got a vulnerability, whether that's because of a mental impairment or something like that, or a particular disorder, or just because of their own sort of personal circumstances. Also now actually applies to defendants. I mean, it's expanding and expanding. But yeah, it was very interesting. I mean, there was like things like having to question using words of only one syllable and, using age-appropriate language. I mean, there's a lot of experts have put in about, how children develop and how they understand words and how they understand language. But also, how you've got to be careful that, say, for instance, one way of testing evidence is to put a question, again, or rephrase it, just so you can say, well, you're inconsistent there, aren't you? But a problem that happened with children was if you asked them a question, they gave an answer, and then you asked that question again, they were going, oh, well, hang on a second, I must have given the wrong answer. And, that they tend to want to please the person, so they would just change the answer. But yeah, it was really, really fascinating. I'll do a little bit more about this, but yeah, just thought I'd just fill you in on that one. So yeah, if you like that, feel free to like, subscribe, and share.